Please be seated. The court is now back in session. We had some issue with the recording equipment before we took a break. That's why there is a delay in the resumption of the hearing. And the National Council for Kyiv Sampon speech was also lost in the recording in his response to Judge Lavange's question. For that reason, I'd like the National Council for the accused to respond again to the question posed to you by Judge Lavange. You may proceed. Kong Sam-on, thank you, Mr. President. Allow me to once again respond to the question put to me by Judge Lavange. Your Honor's question as to who would be the president of the delegate, and allow me to respond as I indicated before the break. In document E3/165, there is a major translation for the word the chairman of the delegate to the chairman of the presidium. And that arose the question. In the Khmer text, it clearly states that it is a speech of the president of the delegate at the opening of the first conference of the first legislature of the People's Representative Assembly of Cambodia. It also clearly states on page 9 in the Khmer text the entire speech of the president of the delegate. Also, the content of this text is about the closing of the meeting as well as the additional confirmation by the president of the delegate. It is on EIN in Khmer 0053 628. My apology is 00053 started with 000, and in French 00301350, and in English 00184063. In the document, the president of the delegate informed about the agenda of the meeting, and in the agenda there are 9 points, and in point number 5 it talks about the selection and the appointment of the head of the State of Democratic Cambodia, or the President of the State of Democratic Cambodia. It actually started on the 14th of April 1976. And the meeting was opened one day earlier, that is on the 13th. And this is my illustration of the mistranslation regarding the term of the of the speech by the president of the delegate. And it is not the president of the state presidium who opens the speech of the first legislature by the People's Representative Assembly of Cambodia. And if the chamber would like to know who made that announcement, then it is the role of the prosecution to say so. I'm grateful, Your Honor. President, thank you, Counsel. The floor is now given to the prosecution to respond to the objections or comments made by the defense team. So you may proceed.
Good morning, Mr. President. Good morning, Your Honours. Good morning, Counsel. Good morning to the general public. Your Honours, the prosecution only has a few brief responses to the observations made by both the Yang Sari team and the Khieu Samphan team. I'll restrict my response to the observations made by the Yang Sari team. Firstly, Your Honours, as you're aware, the purpose of these hearings was to demonstrate the probative value of the evidence contained in the admitted documents before this court, primarily for the public and hopefully as some guidance for Your Honours. The purpose of the hearing wasn't to address the issue of admissibility of documents. The documents that have been referred to in this hearing have been admitted by the Chamber in your decision of June 2012. So the comments by the Yang Sari team that they reserve their right to object to the admissibility of certain types of documents, that right cannot be reserved. As Your Honours are aware, Your Honours have decided on that particular matter. As far as the observation in relation to a statement that was used by the prosecution, a witness statement of Ta Sot, who that witness has apparently died, that again has been allowed by Your Honour in your decision, allowing for statements of deceased individuals to be used in the proceedings. But nonetheless, that statement wasn't used in the presentation in relation to Yang Sari. Secondly, Your Honour, the second main point of the Yang Sari defence was that the submissions made by the prosecution were not relevant to proving the role of the accused, and we would submit that that is clearly incorrect. The prosecution put forward a number of documents in relation to Yang Sari's role to demonstrate his role, and in doing so intended to support five relevant propositions to his role. The first one being, what were the positions he actually held in democratic Kampuchea? The second proposition being, what was the level of authority that he possessed in the Standing Committee and in the Ministry of Foreign Affairs? And the third proposition was, how did he participate in the Standing Committee and how did he participate in the Ministry of Foreign Affairs? And the fourth proposition was, how frequent was his participation, to understand the extent and scope of his role. And the last proposition was, what was the substance of his role? What was the purpose of his role? Not just what positions did he hold, but what was the purpose of the activities that he carried out in that position. And to conclude on that, the prosecution have submitted that the probative value of all of these documents taken together show that Yang Sari's role substantively was to further the cause and participate in building a socialist agrarian society at a rapid pace, and to defend that process by eliminating or killing any enemies that are real or perceived by the party, whether they be internal or external. And that proposition of the substantive role that the prosecution say that he played, we submit, has been demonstrated by the probative nature of all of those documents that were presented. The fact that the documents came from different sources, the fact that they were produced at different times, the fact that they were produced during the regime, and the fact that the documents were both internal or secret documents to the party, as well as external documents such as his speeches before the UN General Assembly. The fact that all of those documents all point to the same thing or the same role, that being to defend socialism in an agrarian society, to build that society and defend it no matter what the consequence to individuals and their lives. That, we submit, is the power or the probativeness of the documents, the fact that they all corroborate and are consistent with that fact. And the defence have decided not to address the probative nature of the documents, and that's a matter for them. But we submit that's the relevant issue Your Honour should be considering, not whether the documents are admissible. That discussion has been had and you've decided, and not whether or not what was said was relevant to proving his role. We would submit it was clearly relevant and is a matter that Your Honours should take into account. Your Honour, that finishes the reply in relation to the Yang Sari defence, and now I'd hand over the podium to my colleague Mr Abdul Haq in relation to the Khieu Samphan defence.
Thank you, Mr President, for the opportunity to respond. I will make a brief response to the observations by the Defence for Khieu Samphan, and I'll address them in the same order in which they were made. The Council expressed regret that it is only now that we seek to rely upon material written by the late King Father Norodom Sihanouk. This, of course, is not a correct statement of fact. We relied on this document as early as August 2010 in our final submissions prior to the conclusion of the investigation. We had this document on our Rule 80 list. We've always intended to use it. It's a document that is on our proposed evidence list. Furthermore, and I'm mindful here of the need to respect the confidentiality of documents which have not been made public, but if all parties in the courtroom and of course the Chamber refer to document E131/1.1, E131/1.1, and in particular item number 23 in the table that is contained in that document, it becomes clear as to why it would have been inappropriate for us to seek to put this document before you at an earlier stage in the proceedings. Now, moving on to the issue of trade and commerce documents, I'm not quite sure what my learned friend refers to when she accuses us of circumventing procedures. What we have done is put before Your Honours a representative sample of a large collection of records which indicate that reports were being submitted on a continuous and ongoing basis by the Ministry of Commerce to Khieu Samphan. As I indicated in my submissions, there are no less than 28 such reports, and in addition there are 50 other documents, Ministry of Commerce records, which contain annotations referring to Khieu Samphan. Reference was made to testimony of witness Sakim Lamut without being taken to a specific page. It is difficult to respond, but even without access to the network during the break, I was able to recall that the witness actually confirmed the subordination of Van Rith and the Ministry of Commerce to both Khieu Samphan and Vaughan Vet. That, of course, is on the record for Your Honours to consider. As to the report written by Ben Kiernan, here there is room for agreement between the defence and the prosecution. We, of course, requested Mr. Kiernan to be brought to testify as an expert in this trial. That has proved difficult, and the Chamber has ruled that he will not be heard in this trial. That does not make his reports inadmissible. Of course, the fact that he is not being examined is a matter that the Chamber will take into account, I am sure, in considering the weight to be attached to various pieces of evidence. Lastly, on the alleged discrepancies in document E3/165, of course, we have no intention of imputing to Mr. Khieu Samphan any statement that was not made by him. We act in good faith, and we will, of course, double-check and triple-check the records. There are, in fact, a number of versions of this minute of the parliamentary meeting in April 1976. We will review them, and we will join the defence in seeking appropriate corrections to translations if there are errors. But I do wish to say the following. The defence have been on notice of this document since at least September 2010, when the co-investigating judges referred to it in their closing order, in the same context in which I referred to it during the course of these presentations. If Your Honours look at paragraph 1166 of the closing order, in footnote 4771, the co-investigating judges rely on this document as evidence of a speech by Khieu Samphan. And then at paragraph 1173, in footnote 4796, the co-investigating judges cite this document in support of a conclusion that it was indeed Khieu Samphan that chaired that inaugural session of the Parliament. The original document reference for this record was 13.13. And if one searches the closing order for that number, one finds numerous references to it. So certainly, Your Honours, we will endeavour to verify the accuracy of that record, and if there are errors, we will, of course, seek to correct them. Having said that, this is one out of a series of speeches that we presented before you, and it certainly in no way appears different in its endorsement of policies as the other speeches given by Khieu Samphan, with which the defence takes no issue. So those are our submissions, and I thank Your Honours.
The President, is there anything else parties wish to add on this?
Monsieur le Président, simplement.
Mr. President, just to come back on what my colleague, Prosecutor Bill Smith, has said on the subject of probative value. In fact, we were talking about relevance. The discussion on probative value can only take place at the end of the discussions, once we have all of the documents, testimonies and proof to look at together. That is just one point I wanted to make at this juncture, so that we do not lose sight of the issue at stake here in the presentation of key documents, which is, of course, relevance.
The President Thank you very much. Next, the Chamber wishes to remind and inform the party that on the 18th of January 2013, Mr. Nuon Chea waived his right to be present during the presentations of the key documents concerning the first and second transfer and also a population transfer and also the document 208/2 and later Nuon Chea Council withdrew this waiver, document E258/3. For this reason, the Chamber cannot conduct the proceedings when Mr. Nuon Chea is absent or when he has already withdrawn his right to be present. On the 31st of January 2013, Mr. Nuon Chea was discharged from the hospital and returned to the detention facility. The doctors who are treating him also recommended that he be allowed to have some rest. On the afternoon of the 31st of January, the trial chamber asked counsels for Mr. Nuon Chea to confirm the position of Nuon Chea regarding his rights to be present during the testimonies of TCW 100 and TCCP 116. Mr. Nuon Chea was again admitted to the hospital for treatment. Currently, Mr. Nuon Chea is still being admitted to the hospital. On the 4th of February 2013, through his counsel, Mr. Nuon Chea shows his position that he has not waived his rights to be present during the testimony of TCW 100. However, when it comes to TCCP 116, his position has already been confirmed by his counsels during the morning session. According to the report we obtained, TCCP 116 can be present before the chamber on Thursday. With that, the chamber wishes to also inform the public and parties to the proceeding that the sessions regarding the roles of Mr. Nuon Chea and the presentation of other documents will be deferred to a later date in which, or by then, the Chamber will inform or notify the parties accordingly. Regarding the testimony of TCCP 116, the Chamber will schedule the hearing on Thursday, commencing from 9 a.m. We hope the parties to the proceedings and the public are well informed, and in particular the parties are prepared to appear before the chamber during the testimony of TCCP 116. For the time being, the hearing on the presentation of document comes to a conclusion, and the chamber will suspend this hearing. The next session will be resumed on the 17th, which is Thursday of February at 9 a.m. During that morning session, the Chamber will hear the testimony of TCCP 116. Interpreter corrects. The next session will be resumed by the 7th of February, which is Thursday. Security personnel are now instructed to bring Mr. Khew Samphan to the detention facility and have him return to the courtroom on the 7th of February 2013. Mr. Evidentiary is instructed to return to the detention facility and return to his holding cell only, where he can observe the proceedings from there. The court is adjourned.